My Lord, my Lady, my Lords, as I say, I'll structure the submissions in response under reference to the structure of the note. I wasn't going to go through everything. The references there are there for the court. One point which I didn't anticipate properly, I'll just deal briefly with in terms of the second respondent's approach to the issue of whether or not there's deference to be owed at the second stage of the weather point, whether the least restrictive alternative is or whether it's made reasonably concluded. It's quite clear why the court gave the answer which it did, because it was asked specifically on that question. And if we just see usefully the extra division's explanation as to what precisely it is asking in question 4, we can then understand the response which is given by the court. And the relevant passage is at page 1849 of the extra division. It's paragraph 42 to 45, so it's pages 1849 to 1851. And we see there that the extra division was faced with argument before the parties at the stage about the... apologies, I should have given the number for that. In argument before the extra division, and there was argument over 8 days before the extra division. It was a very full examination of all matters, the documentation as well as the law. That one of the points at issue between the parties was the extent, depth or intensity of the judicial review which the National Court is required or permitted to exercise in proceedings in which there's an attempt to seek justification under Article 36. And it's noted the parties don't dispute that there's a wide area of discretion in deciding on the level of safety or protection under reference to the motorcycle case. And thus, in general, the level of protection of health and safety within that margin of discretion will constitute a legitimate aim. However, as respects whether there is no alternative measure, at least as effective, which is less disruptive of intra-EU trade, and whether the measure is proportionate in balancing the public interest in the interests of those on whom the measure has adverse effects, there is a significant area of dispute. Essentially, the extent to which the National Court may proceed upon its own evaluation or assessment of those issues on the basis of evidence before it, or should it allow to the legislative or regulatory body in question a large area of discretion in assessing both whether an alternative measure, at least as effective but less disruptive, is available, and whether the impugned measure meets the overall test of proportionality. The petitioners, that is, we the appellants, generally contend for the former view. The Advocate General, in particular, seeks to contend for in reference to the latter. So the Advocate General before the extra division is saying broad margin of discretion on these issues of least restrictive alternative. So the court notes that this has been differently approached at an appellate level under reference, I think, to the Sinclair-Collis decisions before the Court of Appeal and separately before the Inner House, where there was the issue then in the Court of Appeal about the use of a manifest inappropriate test. So against that background of that dispute as the level to which there should be, as it were, deference or an affording of a manner of a margin of appreciation, it is against that background that the court is asked the question as framed by the extra division. And that is, to what extent is the National Court required or entitled to form, on the basis of the materials before it, an objective view of the effectiveness of the measure in achieving the aim and the availability of at least equivalent alternative measures less disruptive. So, against those questions specifically, in which argument was raised before the extra division and before the Court of Justice, the Court of Justice expresses itself in precisely the terms which make the distinction between the approach to the first issue of appropriateness, in which one can give some degree of margin of discretion, but on this second issue of least restrictive alternative, it is entirely clear that one follows what was being argued by the petitioners before the extra division. That's why they've made that distinction. It's not an accident. It is consistent in the language versions that I've looked at, and it's there precisely because of that controversy that existed in Sinclair Collis, which was also alluded to, of course, in the Lumsden case. But this is the authoritative statement from the Court of Justice. And, of course, this court, as a European court, acting as European judges, follows the judgment of the court on this point in this case. There isn't any room for doubt or reference to other cases they've done differently. This is what this court is instructed in this case. So, that's that point. But again, just specifically in terms of the second respondent's case about whether or not one has to go through national procedural issues of degrees of deference to the courts below and the like, the position which we adopt and have adopted in our case, and have answered that, is that basically there is a fundamental obligation on this court to make sure that full effect is given to the Court of Justice's decision on the facts and law of this case. There isn't any space for deference to what the First Division thought or what the Lord Ordinary thought. It is an issue of how is EU law to be applied. That is something which is mandated of this court, of course, under Section 3 of the European Communities Act, but is also an issue which is required as a matter of the maintenance of good faith among the institutions of the European Union, in which I include the courts of the Member States, as mandated under Article 4.3 of the Treaty on European Union. If one wants any case law to that effect, I won't take the court to it, but Kernkraftwerke is produced. The relevant citation it's in Authorities tab 51, page 3417, at page 3445, paragraphs 31 to 36. And that's simply authority for the proposition that any provision of a national legal system, including provisions of a constitutional nature, and any legislative, administrative or judicial practice which might impair the effectiveness of EU law by withholding from the national court having jurisdiction to apply such law, has to be disapplied. So that's the principle that applies here, and that cuts through much of what was said by the second respondent, the UK government. So, going on specifically to the speaking to the response, as I say, I'll go through that in a relatively short course. But the general response sets out the position that in our opening oral submissions, the position was asked of the respondents is why not tax? And frankly, we have not had a satisfactory or response which accords with the requirements of EU law. What has to be established is that tax cannot be used to achieve at least the same level of protection of the life, of health and humans, whether of the targeted group of hazardous and harmful drinkers or of the population of Scotland as a whole. And it is quite clear that tax can be so used. It can be used. That cannot be gainsaid. There is nothing which has been said. What has been said by my learned friend is why they don't want to use tax. And that's set out, as they say, in their Article 4 paragraph 4.3 of the BRIA, and also in the policy memorandum at pages 799 to 800. They set out reasons why they think they don't want to use tax, because they think tax will not be as efficient in whatever aim it is that they think they are pursuing. But that is not the question. The question is, is it not possible to use that? Can tax be used? And if it can, then it has to be, this is not the restrictive alternative. And on that point, because in a sense it might cut through everything here, the fact that the Lord Advocate, in his closing 5 minutes of his submissions, for the first time accepts that there is a taxation measure in Article 1, subsection 2 of the 2008 directive of indirect taxes, which shadow excise in its approach, is open in theory, in potential, constitutionally, as a matter of EU law, certainly, to levy health tax, ad valorem tax, potentially, in terms of alcohol products, which can be restricted to Scotland. That is an alternative which is accepted for the first time, which has been as an issue which has been raised by the petitioners from the outset of this case, under reference to Commission Against France in 2000, which is even referenced in the original petition 5 years ago. Until 1 hour ago, we were told that is not an option, and we most certainly have not considered it. And they've most certainly not done any modelling, because up until 1 hour ago, they said there was no such power. Well, there is. That is a fiscal alternative.
Can we just define it precisely? I've got a note of what he said, but just want to see that you're putting it exactly the same way.
Yes.
What is he accepted, which is the key?
As I understand it, what he has accepted is that, contrary to what was set out in the case, yes, at paragraph 515, which was to the effect that it would not be possible to have excise, in some sense, modified specifically to Scotland.
Right.
He said that that was not a matter which was possible under EU law. Having had his attention drawn once more to Article 1.2 of the 2008 directive, and which was previously 3.2 of the 92/12 directive, he has for the first time said that...
You also said he accepted indirect tax shadowing something which could be restricted to Scotland. Shadowing?
I'm just shadowing, in terms of it has to, under Article 1.2 of the directive, it has to use the same bases, the same general principles as either excise duty or,
so the same bans
VAT.
In the case of wine?
I'm sorry, my lord.
Same bans in the case of
not
wine?
Not necessarily. The cases are not entirely clear on it. No. That hasn't been determined. In the case of Commission Against France, what was in fact put was an ad valorem tax only on spirits over 25%.
Yes, I see.
So it could actually be more targeted than that. It's just the general principles, but not. It doesn't have to be.
So you have specific. What in Scotland could you therefore have a specific tax which was different for 10% and 12% and 13%?
Well, that appears to be the case from Commission Against France, which, as I've said, we've drawn to their attention from the outset. That and it might be, if proper reason can be given as to why one's making that differentiation, and that this is not some kind of interference in the market to buck the market, as it were, but if it's got properly substantial health bases or whatever it is. Certainly in Commission Against France in 2000, the 25% tax, or the tax on spirits over 25%, was justified in terms of the health risks associated with the consumption of such products, and the money raised was then put into the health fund in terms of French national security.
And can you remind me, if it were an ad valorem tax, how would it have the same tax base as excise duty?
Well, Lord, again, it is a provision of the excise of the directive which has not been litigated on very much. There have been, to my knowledge, just been 4 cases on it in which the issue has arisen as to precisely what is meant under Article 1.2 of following the same general principles as either excise or tax.
Yes, but I don't have it in front of me, but I think it referred specifically to a tax base.
Yes.
Yes.
The tax base of excise duty was seen as depends on the drink, but for some it's volumetric, for others it's the alcoholic content?
None of the cases say that one has to follow in detail. What the cases do say are that one has to follow general principles, and it just depends on the particular facts of the case. So, in Commission Against France, it's on spirits of a certain level, which is not prefigured anywhere in the directive in terms of you will be taxing more for those over 25% as opposed to those under. There's an Evangelische Kirche case, which hasn't been produced, but it's also from 2000, which is to do with a tax on ice cream, actually, and alcoholic drinks. And there's some discussion there about whether they can follow VAT or excise, but generally it's left open. There's the case, the Jordi case, which the Catalan case I've referred to, and then there's the Estonian case, which I haven't produced, but happy to do that. Those are the 4 cases on what is now Article 1.2, and there is a general discussion of general principles. But as I say, this is a point which we raised 5 years ago, and for it simply now to be conceded in 5 minutes at the end of your submissions is really not perhaps what one would expect. But the point is they have conceded the point, and they concede that they have not modelled that issue. And they haven't even considered the issue because they didn't even apparently look at the law to check that that was something which was open to them. So, that in a sense means I win, because there is a less restrictive alternative, and they've done nothing about establishing the relevant evidence to say why it has not been used or why it cannot be used. And such evidence as the court does have, however, says that an ad valorem tax, and that's the February 2016 paper, can be used to achieve the same level of a reduction of in alcohol-related mortality as 50 pence per unit on alcohol in England. Now we're told that that February 2016 model in England said that 50 pence per unit in England would reduce alcohol mortality by 4.3%, whereas the vast claims in the BRIA that the same amount would reduce mortality by 17% have now come down to 7.6% in the April 2016 Sheffield paper. But the point remains there must be some ad valorem tax, because according to Sheffield, that can be modelled, which would achieve those same benefits. So, they have the information from their very own papers, these Sheffield papers in February 2016 and April 2016, which tells them about how ad valorem tax, in addition to excise, might be used, and they have done nothing in terms of seeking to model it. They could have done that, but they restricted their instructions to Sheffield in April 2016 to look at, and to look only at, the idea of hiking excise duty without any reference to any changes or any of the other sophisticated modelling that is expressed by the same authors in a paper just 2 months previously. So that's the evidence the court has. That kind of tax can do what MUP does without distorting the market. Now, we know, because again it was established before the court below, that tax is better at protecting the population as a whole. And the First Division noted that, and I've quoted it, in this area, and this is at page 2 of the note. In this area, as the first respondent expects, the government cannot pray and aid the objective of a general reduction in alcohol consumption as justifying the legislation in terms of Article 36, since an increase in tax across the board could achieve that simple objective, assuming the increase was reflected in retail prices. So, one of their objectives, they've said, MUP is not, and so this, once more, this was admitted before the Extra Division, it's repeated before the First Division, it is not appealed against. The second issue is that in terms of protection of hazardous and harmful drinkers, once again, the analysis put forward by Advocate General Bott makes it entirely plain that tax protects hazardous and harmful drinkers better. We know it has to do that because the phenomenon is that hazardous and harmful drinkers one, increase with affluence. The numbers increase, the proportions increase quite significantly as one goes up the income quintiles. And at the same time, as the extra division noted, their tendency of the rich to buy the cheaper alcohol that would be affected by MUP goes down. So if you are interested in reducing the consumption of the hazardous and harmful drinkers as a cohort, then tax does it better than MUP. So it's in response to that, in a way which departs from the very terms of the Statement of Facts and Issues, which was agreed after some painstaking emailing over a number of nights, as to the wording of what the aim of this legislation is. And we are told it's a general population measure, but it turns out that tax is better if you want a general population measure. It's a measure which is aimed specifically at targeting hazardous and harmful drinkers. But we know that hazardous and harmful drinkers, being associated with affluence, will be better protected by tax also. When this is once more pointed out before this court, as it has been throughout these proceedings, we're then told, actually, what you have to do is when we said that the legitimate aim that we all agreed on, actually, we fooled you. You thought that when we said that we had a general overall population aim, we didn't really. You thought that we said, when we said that we were trying to protect hazardous and harmful drinkers, you foolishly thought we meant hazardous and harmful drinkers as a whole. But if you had unpacked the word targeting, you would have realized that what we really meant was the hazardous and harmful drinkers who are going to be really, really badly affected in terms of their health if they keep on drinking cheap booze. That is the 1% of poor, harmful drinkers. If they wanted to say that was the aim, they could have. They could have put that in the Statements of Facts and Issues, and we would have had disagreed, and we would have created a case in pointing out why that could not be done for all sorts of constitutional reasons, apart from the fact it wasn't supported by anything in terms of how the legislation was presented to the Scottish ministers. That was not done. All we get is, this morning, another shift. And this has been happening throughout this litigation. Every time you just ask them, what is the legitimate aim you're looking for? If there's a problem, they shift it and say, no, you've got to read it so that you understand what the underlying policy is. And so the words that we say are not to be taken at face value. But now, hey presto, it's the legitimate aim is not even now being expressed in terms of the protection of harmful drinkers and poverty, which seemed to be the general thrust in terms of the April 2016 Sheffield paper. It's now harmful drinkers whose health is most likely to be badly affected by alcohol, something of that sort, something made up on the moment. Now, that is not. My learned friend properly says, the Lord Advocate properly says, the key issue in this case is what is the legitimate aim of this legislation. And we know what that is because the Court of Justice has said it and the parties agreed to it. They cannot come here on the morning and come up with a new aim, which is precisely what they're attempting to do here. That is not to be allowed either procedurally or constitutionally. We argue with what we argue, and when we see what we have, which is the class of moderate drinkers can be affected by taxation, and the class of hazardous and harmful drinkers can better be protected by taxation. There it is. Because the basic position is that you are not permitted, as a matter of EU law, to discriminate against particular products that you think are undesirable because they're cheap. The issue is, and so you therefore, because that constitutes discrimination, the whole point about a system of fair competition which allows for the free formation of prices, which is what the single market seeks to achieve is that the state cannot come in and say, but some of those prices which have been formed under the free activity of the market are not desirable. And so therefore, just for those products, we are going to insist that they be increased. But that just goes against the absolute fundamentals of the free market principles and procedures on which the EU is based. You cannot target some products because of their price and insist that those products and those products alone have their prices raised. If you have chosen to use pricing as a measure with which to discourage consumption, yes, you can do that. But you do that in a manner which is compatible with competition law, which means that you raise prices for everyone, for all the products, because otherwise you're distorting competition. You raise prices for all the products by imposing taxation uniformly across it. That's what avoids discrimination, but allows you to achieve the policy aims which you say lie in justification. In this case, that means that the policy choices, yes, they are constrained, that you cannot pick on cheap vodka or white lightning cider and say, we insist that you raise your prices to that of a competing product of a similar strength. Because in so doing, and we say, well, we have to do that because that's the only way we can stop the undesirable consumption of this product. You cannot do that. If you want to raise the price, you raise the price by everyone. And if price is too blunt an instrument, you use other measures. But that's part of the discipline of being within the single market. And as the court says, and I quote at paragraph 4.9, it's for the member states within the limits imposed by the treaty. You cannot just do what you think is the right thing. And you certainly cannot say, there is a problem in West Central Scotland. Something must be done. MUP is something, therefore we must introduce MUP. That seems to be how it's approached. It's got to be, the policy is in accordance with the limits imposed by the treaties, always bearing in mind, as the court has said, the requirements of free movement of goods. And that is not something upon which, as we've seen from articles, from paragraph 59, on which the member state has a margin of appreciation. That is a matter for this court to determine on the materials before it. What are the limits of the treaties? That's what it comes down to. What are the requirements of free movement? Those are legal questions, not questions on which differing policymakers can have differing views to which this court should accord some form of deference. Going on to the issue of the BRIA, section 5, and just for the sake of thinking, I'm formally adopting this note as my submissions.
Yes.
As coloured. And I've also formally adopted the case. So, the BRIA and its limitations, we set out what all those limitations are. Leonard Friend suggested that, in fact, the BRIA looked at trade in wine, he says, and it shows there was a very small decrease. I mean, it's quite strange. I mean, there are these claims that there will be a 17% decrease in mortality in the BRIA, but only a 3% decrease in consumption of wine. Again, that just points to the certain model and perhaps some of its limitations used. But what it is not is an analysis, an economic analysis of what actually happens. It's an econometric prediction. But in any event, even on that econometric prediction, there is no differentiation made in that prediction as to the impact upon the EU and not the EU. The BRIA, remarkably, doesn't mention the EU. It talks about abroad, somewhere else. When it mentions cross-border issues, it means England. That's not good enough. This is a measure which clearly impacts upon trade. A properly founded and based measure would be one which took into account the effects specifically, not because it's abroad, because it's imported, but because it comes from other countries in the EU. And not only is it a product that comes from other countries in the EU, but in the case of wine, it's actually covered by the Common Agricultural Policy and the Common Market Organisation. So you would think that when you were dealing with a measure, which you do understand also has an impact on importations of wine from other member states, that what you would do was say, and we've checked how this accords with the Common Agricultural Policy and the Common Market Organisation, and we think this. And they have done nothing of that. Nothing, not in the BRIA, not since.
You've checked in what?
We've checked in the BRIA, sorry.
Yeah.
The impact assessment, Lord, but they've done absolutely no assessment at all, at any point, even now, after the court directs it in paragraphs 28 and 29 to how will this impact on the Common Market Organisation in wine, they still have produced nothing. The Sheffield report has nothing about EU trade and nothing about the Common Agricultural Policy. And all they say is, well, it's not that big. It's just a small impact. Look, there's hardly any wine that's affected. Look, Spain's only got 10% of the market, and it's only half of that which is going to be affected by this measure on our best. That's a significant impact. You would think that it would be not beyond the bounds to actually maybe drill down on that and see exactly what might be happening. How compatible is that? How will that affect Spanish viniculture, viticulture and the like? No, we won't do that because abroad's abroad, apparently, and cross-border is England.
Yeah.
So, maintaining a balanced, positive and enjoyable relationship with alcohol, we're told, that's what this is all about, and it's perhaps picking up some of the issues which were raised by my Lord Sumption. When my Lord Sumption refers to the undesirable side effects of taxation, and that the Court of Justice had got it wrong somehow because in Articles 48 and 49 they hadn't taken into account the undesirable effects of taxation on, as I understood it, and I may be wrong, on moderate drinkers. Now, what exactly are those undesirable effects of taxation on moderate drinkers? And how is it they come in to the balance that my learned friend talks about, the balanced, positive enjoyment relationship with alcohol? Well, in the first instance, if we are talking about some kind of economic inconvenience to moderate drinkers because they're having to pay more and their health is not being affected, and that's just unfair. Is that perhaps one of the indirect effects my Lord Sumption had in mind? If it were, that would not be a matter which could properly be taken into account when determining whether a justification had been made out under Article 36. Because, of course, the court's case law is entirely clear that economic considerations cannot be taken into account and used as a factor when determining whether or not a justification has been made out under and in terms of Article 36. Article 36 is all about non-economic considerations. You cannot build into it. It's not really fair. These people aren't suffering health effects. They shouldn't have to pay more, for example. Or, well, it's not really fair. It means like you have to pay more in the pub, whereas this measure at least means it's only if you go down to the off licence that you'll actually experience an increase in price. This matter of the non-economic considerations not able to be used is looked at and referred to in the case of Deutsche Parkinson, which is at Authorities tab 45, page 3190.
What bundle?
The bundle is,
2D, I think.
or not 2D, yes it is. 2D.
Sorry, why do you call them non-economic considerations? I thought they were economic
Yes, no,
considerations.
I'm saying Article 36 allows for non-economic considerations to be brought in, but the considerations that I understand are being prayed in aid about the inconvenience to the on-trade,
Yes,
or the upset that moderate drinkers who don't need to stop drinking as much are going to have to pay more, is an economic consideration. And that is not permissible as a matter of EU law. The particular paragraph and the page of the Deutsche Parkinson is at page 3178.
This is in the opinion of the Advocate General, is it?
It's the Advocate General. It's just, I mean, but he's referring back to earlier case law. The case law commission against Italy in 1961 on this point, and the case of Decker is the leading case, of course. But he footnotes them. But it just happens to be this is the one case where this phrase is actually used. I could have brought others. But he says at paragraph 42, last subground of justification cannot be developed. This is in relation to Germany's attempt to justify minimum prices, I think, in relation to pharmacies selling drugs. And one of the justifications is Germany, which relies on the health exception, stresses the measure in question is necessary to ensure a consistent supply of pharmaceutical products, to ensure the quality of such supply, and to control the cost of developments in the health sector, an economic consideration. The last subground of justification cannot be invoked. Given that Article 36 is directed to eventualities of a non-economic kind, measures designed to reduce the cost of social security schemes may not be justified under that head of health under Article 36. Only the risk of seriously undermining the financial balance of the social security system may constitute an overriding in reason in the general interest, which, given the exceptional nature of that ground of justification, is clearly not the base here.
But they're really saying here that this wasn't within Article 36 at all, because it wasn't a health
the first two were
measure. It was just a tax. It was just reducing governmental costs.
No, they're saying that the justification offered in terms of subsection 3 at AG at Advocate General Opinion 41, paragraph 41. It's only in relation to the last subground of justification he's dealing with that. I think they accept that the others, assuming a consistent supply, would fall within Article 36.
Yes, I accept that, but here we've undoubtedly got a health aim.
Yes.
But it is achieved, or to be achieved, by an economic measure, namely minimum pricing.
Yes.
So why can't you take into account, if you're considering a substitute economic pricing, namely tax, the potential disadvantages of a tax, which are that it would not only have the health benefit, but it would also have a disbenefit for a whole lot of people whose health you're not addressing.
Because what is the disbenefit?
Well, the disbenefit is the extra cost imposed on moderate drinkers whose health is not at risk.
And that is an economic consideration.
Well, I know, but so is the economic consideration, which is leading you to get the health benefit. It seems rather curious you can take into account one side of the equation and not the other.
But in terms of the justification which is being offered here for a measure which is accepted breaches or falls ex facie as a breach of Article 34, you are allowed to justify on the basis that it protects the life and health of humans. You are not allowed to justify it on the basis or say or count against it that it imposes costs. That is an economic consideration. And in any event, the disbenefits have never been established, and that is an issue which again was pointed out before the Court of Justice by the Advocate General, because there's so much which is familiar in the submissions, not all of it in terms of the change of legitimate aim, admittedly, but the issue of, well, the reason why we've thought about getting this balance to maintain the balanced, positive and enjoyable relationship has been required is because we don't want to put too much burden on moderate drinkers. But the Advocate General, I think at paragraph 149. I'm just trying to find the... In this case,
149.
I think it's 149. Yeah. Do you have that ready? Sorry, I have the thing here somewhere. Is it there? Is it 149? The Advocate General mentions that the reliance on the disbenefits to the supposed disbenefits to moderate drinkers is not something which has ever been vouched by actual evidence and was simply assertion.
Where's that? Then you haven't got that.
Well, there are figures produced.
I'm told it's 1893 page.
I mean, look, the Lord Advocate has produced figures showing how prices of various products would have to rise in order to achieve a price level comparable to the 50p MPU. And there are obviously very substantial price rises.
Sorry, my lord, I didn't quite catch that.
But the Lord Advocate has produced evidence, there's a table in his case, setting out the percentage increase in the price of products which would be needed if you were imposing a tax on the products so as to achieve a similar price floor to an MUP.
Yes. That's not evidence in terms of disproportionality, because all that is a calculation, and I haven't seen the calculations, and we do criticise some aspects of that. But what that is doing is building up the worst possible case, which is that MUP has to be, that there has to be a floor price of 50 pence per unit, and that to ensure a floor price there, and just look, you might get massive health benefits, but it's all going to be terribly expensive. But there it is, but from their own studies of the Sheffield studies, and we don't accept that, they say you don't need to go up that level to attain an overall reduction of deaths. You only need to increase by 27%. To have a reduction in deaths of hazardous and harmful drinkers, you only need to increase existing excise rates by 28%, and they haven't done any of those calculations. And even for the poor drinkers in poverty, their best possible case, you need an increase, they say, of 70%. So they could have modelled all those, but they haven't done any of that. But in any event, it is then assumed, perhaps, it's judicial knowledge, but I don't think that's sufficient for the purposes of establishing a justification under Article 34, that it will be economic disbenefits accrue to increasing taxation, when that taxation is going into the public fisc and may be used in all sorts of other ways. So one cannot simply say, well, isn't it a bit much that moderate drinkers might have to pay more, and then give the worst possible option. And this is what they'd have to pay more if we push everything up to 50 pence per unit, which would go way beyond everything that we'd ever said we actually wanted to achieve by this measure. So it was paragraph 149, page 1893. Advocate General says, on the assumption that the objective rules at issue is generally confined to combating the hazardous and harmful consumption of alcoholic beverages, which is for the referring court to determine, although, as it turns out, the court itself determined it, so it didn't follow that. I consider that it is for those responsible for the drafting of those rules to show that increased taxation is not capable of meeting that targeted objective, to show that increased taxation is not capable of meeting that objective. However, they adduce no serious evidence to show that, as they maintain, increased taxation would have a disproportionate impact by comparison with the objective sought. It must be stated that they claim principally that such a measure would have an unnecessary effect on moderate drinkers who do not incur the same degree of risk. Like the referring court, I am unable to see how the collateral effect of a general increase in taxes might be seen as negative in the context of combating hazardous or harmful alcoholic consumption when Scientific studies show that hazardous or harmful consumption rises in line with the increase in consumer income, while at the same time the quantity of the cheapest alcoholic beverages bought per week falls with that increase. No serious evidence. The same claims are trotted out. They are told, if you have to do this, you produce evidence. You don't just simply make unsubstantiated claims of general disproportion and inconvenience. Similar claims were made by Cyprus in a case which we quote in a case in our case commission against Cyprus, and the court has short shrift over that by saying it's not enough to assert, you have to prove, and they have not proved anything of the sort. But in any event, and perhaps again picking up some comments made by my Lord Sumption, the problem, the issue about whether or not alcohol, people, moderate drinkers can have, and the Scottish Government's one of its aims is to ensure that moderate drinkers get to continue their balanced, positive and enjoyable relationship with alcohol. That's what they say sometimes, but other times they say alcohol is a psychoactive, toxic, addictive substance which really is so associated with health risks, no matter the level of consumption. There are no safe levels, they tell us. That it is important, essential. That is why we can justify a general population measure, because moderate drinking is not harmless drinking, is what they otherwise tell you. And the main narrative they have to that effect is seen in their submissions to the Lord Ordinary. And it's worth looking at those briefly. 624 to 6, paragraphs 6.3 to 8. So MS page 624.
Yep.
So, in response to our claims that alcohol was a safe and ordinary product or a commodity, they say, no, the explanatory notes have it set out that alcohol is not an ordinary commodity. It's a psychoactive and potentially toxic and addictive substance and a contributory factor in 50 different causes of illness and death, ranging from stomach cancer and strokes to assaults and road deaths. And then they cite and quote in full a range of conditions which are wholly attributable to alcohol consumption, and those which give an estimated risk associated with daily doses, partly attributable to alcohol consumption. So we see a whole series of, even if you have a daily dose of 25 grams a day, which is well within safe limits, you run risks of cancer of the lip, oral cavity and pharynx, esophageal cancer. The list goes on and on. They deny that alcohol might have a protective effect against specific diseases. They say that's an anomaly. Taking alcohol is dangerous, and not because of exceeding government guidelines, just if you're a moderate drinker. That's what they say to the Lord Ordinary. That's why they say it is justified as a measure, general measure against all. But having accepted that, taxation is the way forward, as they themselves apparently now appreciate. The Sunset Clause is not relevant to this. The idea, again, the Sunset Clause, which they play much reliance on, is relevant, if relevant at all, to the issue is whether or not this will, in fact, cause the increase in drinking and the increase in public health which is claimed for it. That's where the scientific uncertainty lies. That's why the Sunset Clause is thought to be relevant, because it's taking into account those issues. But it is not an issue for the Sunset Clause, nor is it an issue of scientific uncertainty as to whether or not these measures can be achieved by taxation, the measures of reducing consumption. That is a matter of simple and straightforward economic analysis. Waiting 5 years to do that economic analysis is not something which is permitted or mandated by the court in this case. The evidence on economic impact is there and uncontradicted. It's criticised, but the Yarrow and Decker reports make it entirely clear that MUP at 50 pence will have impacts not just on for example, the wines of Bulgaria, Spain, Italy and Romania, which at the moment are imported at relatively low levels, but on individual producers in other member states who produce alcohol imported into the UK at relatively low rates. So this isn't about countries being affected, this is about producers. The whole point about Article 34 is to protect individuals' rights, not countries' rights. This is a supranational system, not an international system. So Yarrow and Decker point out, for example, the makers of Bavaria beer, apparently they're Dutch, which is particularly economically produced, will be directly and immediately impacted by this. So it's not enough to say, oh well, some countries, look at that, Romania's only got 0.1 of the market. That's not the issue. How many Romanian or Bulgarian producers are affected? They should check on that. They haven't. And it's not as if that kind of information is unavailable. The Common Agricultural Policy is readily full of statistics and maps and charts, which could at least allow that kind of analysis, which the court says has to be done under reference to paragraphs 28 and 29 of its judgment in terms of the CMO. So trading down in excise, as we say, there is no trading down. If you do create some form of floor price, as we've said, will be done. The rise in excise needed to achieve 50 pence per unit. That's the point discussed with my Lord Reid already. As I've said, that the table is not evidence. It's simply extrapolation. It's just applying some kind of percentages to a price survey, and it's done at only in relation to one possible measure. So it's effectively a straw man, because the equivalent level of decreases in alcohol mortality can be achieved at much less. The business about it all being simple and easy to understand, the constant reference to the motorcycle case in Italy. I mean, really, can we just actually remember the facts of that case? And that is that in Italy, the Italian government thought it unwise for Italians to be trailing trailers behind their motorcycles. And so it said, if you're Italian, you don't get to pull a trailer behind you. You can if you turn up from other member states. We're not interfering with others' free movement on their motorcycle trailers. And so the Commission takes them to the Court of Justice saying that's an infringement. You're decreasing the overall European sale of motorcycle trailers. The Advocate General says, yeah, why don't you, if you're really concerned about road safety, have particular bits of the road or particular roads, mountain passes, dual carriageways, or maybe you can use them in dual carriageways, but not. Why didn't you sort of make it sort of targeted? And the Italian government says, we're Italians. It's so much easier, rather than putting up road signs everywhere saying, you Italians can use this motorcycle here, but you can't use it there. If you just say, you don't get to use them. And that's it. That's all the case says. What it most certainly doesn't say is that a measure, MUP we're told, is very simple, because you can work out what the amount is, and it's only in one clause of the law. It doesn't say that the law has to be simple as opposed to complicated. Isn't excise difficult? It's far too difficult, therefore we shouldn't be litigating in that aspect. It's the result and the enforcement, and in both issues, if you impose minimum floor prices with excise, that has to be enforced in exactly the same way as MUP would have to be enforced by the same trading standards officers, and all they're doing is checking the price by applying a formula. It's not difficult, it's very easy to understand. We have computers that can do that, even if others can't. But I want to conclude with the important issue in this case, which is that this is not an attempt to prevent the Scottish Government from tackling cheap alcohol. This case is not about Scotland, it's not about Buckfast, it's not about the politics of devolution, it's about the enforcement of the law and international trade. And the decision in this case will set a precedent and an example across the world at a time when international trade is of particular interest and importance, both in terms under the WTO, which has provisions, as we see in the petition, which parallel Articles 34 and 36. And all that we are asking for, as we have asked in other fora, including before the WTO, that international trade law be upheld over and against the particular vagaries of national politics or policy choices. They can achieve these aims. They just have to do it all lawfully. They have accepted that there is a lawful option open to them, specifically in terms of the ad valorem tax, which they had not previously considered. That is what they can and should be following. It is clear that there is a general international impact on this, not only from the fact that the Commission took the matter and reported on it, but that so many member states turned up and gave their reasoned opinions to the Commission on this matter, and those are produced in the bundles. There's about 10 member states. So they don't think this is all about Scotland not getting to deal with its problem in alcohol. They think this is about international trade, and they are right to think so. And similarly, at the hearing before the Court of Justice, there was a broad representation from across the member states, and indeed even before the European Economic Area, in that Norway also turned up unusually and gave its submissions. So, as we've said, the Court of Justice is keen on absolutely central that the maintenance of the conditions of free competition, of fair competition, and the allowance of the free formation of prices is absolutely central part of the DNA of the EU. That is why in every case in which minimum pricing measures have come before the Court of Justice, before the Commission, the number of cases about tobacco in particular, I think particularly it needs strong health justification for limiting sales, they have all lost. There has not been one case, most recently the Deutsche Parkinson case, in which the court has said, actually, yes, it turns out minimum pricing is justified for health measures. They say, no, health measures, yes, use tax. And that's what this court should uphold in upholding this appeal.
The cases you're referring to, they were by the Commission, were they against countries? Or?
Yes, we call them the tobacco cases. It's Commission, there was 3 of them in 2009. They're referred to in the Court of Justice case law because there was an attempt by the Lord Advocate to distinguish them, saying, well, that's all about smoking, we're all about drinking. And they said, and it wasn't the issue as to whether or not excise rates will ultimately be passed on. And they said, of course they will, because we're dealing with a market here, and ultimately profit's what's important. And they go back, there's Commission against Greece from 2000, but and there's been a subsequent Italian case. So yes, they're all enforcement actions. So I think I've reached my time, Lord and ladies, unless I can assist any further. Those will be my submissions.
Thank you very much indeed.
Well, Lord, I'm not going to reply to my learned friend, but in light of one part of his submissions, there is an authority that I need to draw to the court's attention.
He can obviously reply on it, yes. He can obviously reply on it.
Absolutely. It's a case that does deal with the question of ad valorem taxes in relation to Article 1(2), and which makes clear that an ad valorem tax under that article can be introduced only if it complies with the basic structure of VAT. And not
What's the case? Have we got it on our... We haven't...
It isn't. It's a case...
Have you got copies?
I've got some copies here.
Well, perhaps the easiest course... You just want to take us to the paragraph?
I'll take the court to the paragraphs.
Very well.
That's the case about taxing ice cream.
Thank you.
Yeah.
Thank you.
Yeah, that's, I mentioned it.
Yep. So,
If the court goes to paragraphs 47 through to 49 of
Good.
the decision of the court at it's at page 871,
association. 47 to 49 on
47
871.
49.
Thank you.
And the point made in paragraph 47 is that under 1.2, this concerned an ad valorem.
Yes.
The provision doesn't require member states to comply with all rules applicable for excise duty or VAT. It's sufficient that they should, according to general scheme of one or other tax techniques. It then goes on to say that the beverage duty in question didn't according to the general scheme of the rules relating to excise duty, because its amount is determined in relation to the value of the product,
Yes.
not on the basis of weight, quantity, or alcohol content, nor in relation to chargeability, because it's chargeable only at the stage of sale to the consumer.
Yes, I see.
But that does suggest that if you had a band, you would still be charging by reference to alcohol content, even if you just
It
selected
does.
12%.
I can see that, my lord. As my learned friend said, that's an unresolved question. That's an unresolved question.
Very well.
And then at 49,
Yep.
it goes on to say that it doesn't, according to the general scheme of rules applicable
Yes.
for VAT, while not incompatible with the article, relevant article 6 directive, doesn't comply with the rules applicable for VAT in relation to calculation and chargeability, since it's charged only at the stage of sale to the consumer,
Yep, not
charged
charged,
at
yeah.
each stage in the
Yeah.
production and distribution
Yeah, yeah.
process. So I draw that to the court's attention simply because of the submission that my learned friend
Very
made
well.
at the outset of his reply.
Yep. Thank you, Lord Advocate. Anything you want to say about it, Mr.
It was, in fact, the case I was referring, my Lord,
Yes.
Reid to, but it has to be read against the case of Commission against France, which I referred my Lord Mance to, which is the 25%
Yes.
proof of alcohol. But the Commission against France is referred to in the Evangelische case.
Thank you very much. Well, we're very grateful to all three of you for your submission, and we're very grateful to all those who were involved in preparing the written cases. We will consider this case and let you know our decision in due course. Thank you all very much indeed. Court's now adjourned.